Good evening, immigration family. How are you? All right. I guess you guys know what we're going to talk about today for sure, right? I'm going to wait for people to join me, but can I tell you how excited I am to talk about the breaking news, Biden's new process for undocumented spouses of US citizens to get a green card, okay? That's what we're going to be talking about today. So please join me if you know anyone who this may affect, somebody who is looking for a pathway and may benefit from President Biden's new rule. Please get them to come in here because we're going to dissect what was said. We're going to dissect what was not said. And at the end of it, you cannot hear. Okay, who cannot hear? All right. Wow. Why can you not hear? Hang on, guys. Let me see if I can move this to something else. Can you hear me now? If you can hear me, give me a thumbs up. Can you hear me now? You're hearing me. Okay. What about you guys on Instagram? Can you hear me? Instagram, can you hear me? Facebook, can you hear me? YouTube, can you hear me? Give me a thumbs up, please. Let me know if you can hear me, because I know Instagram can hear me because I'm on my phone on Instagram, but on the computer, I need to know that you guys can hear me. Facebook, can you hear me? YouTube, can you hear me? No response. Let me post here. Can you hear me? Yes, you can hear me. Thank you, Lion Ray. Good, because I am itching to get into this topic. Guys, at 3:30 today, I think it was like three-ish, President Biden came in to give an announcement. I canceled everything because I had to hear it from the horse's mouth so that I could deliver the information to you guys. Awesome. So for those who do not know me, my name is Ifeoma Odunlami. I'm an immigration attorney from the Odunlami Law Firm. We're here in New Jersey, but we serve clients in all 50 states. Can I tell you that we have been waiting for this news for a long time? I am so excited, and I want to break it down so that you guys understand what was said. So basically, as part of their agenda, the Biden administration to promote family unity, this is what the Biden administration they proposed this new rule, which is going to go into effect sometime in the summer. They haven't told us when, but this is what it is. So basically, if you are an undocumented person and you're married to a US citizen, you stand a chance of being able to get your green card within the United States, and you don't have to leave to go outside the country. Now, I remember when I posted this one time, somebody said to me, well, if you're married to a US citizen, you can get your papers anyway, you can get your green card. But let me tell you the fine distinction. If you come into the United States without being inspected and without being admitted, which means, for instance, you come in through the border, right? Even if you're married to a US citizen, you cannot get your green card within the United States. You cannot adjust your status to that of a green card, a green card recipient in the United States. You must file a waiver. A waiver is called a provisional waiver, I-601A. You have to request permission. You have to request a waiver, which is a forgiveness for having been here unlawfully. And then you can only get that waiver by showing that your US citizen spouse or parent, US citizen or green card holder spouse or parent, will suffer extreme hardship if you are not allowed to stay in the United States. And if you're successful and that waiver is approved, you have to leave the United States and go back to your country, go before the consulate, do out your interview, and if you're successful, then you get to come back to the United States and have your green card. So a lot of people are afraid of that because there's no guarantee that if you leave, you could come back. Because sometimes people leave and then there's a problem because maybe there's something they didn't tell their lawyer, which now becomes a problem and they have to stay longer. And so for a lot of people, there's a lot of anxiety about leaving the United States. They're leaving their family, they're leaving their children, spouses, and they don't want to leave. But then they can't get a green card here unless they leave. And for some people, they may not even qualify because they don't. They may not have reached the threshold, which allows them to show the extreme hardship that is needed. So what this law does is for people who need that waiver. So if you came into the United States with say a B1, B2, F1, or you came in with a visa, or even came with ESTER, which is you're from a country that doesn't require you to have a visa, but you were inspected, you were admitted into the country. Even if you're no longer in status, you can still adjust your status. If you're married to a US citizen, you can get your green card. That's not a problem. So for you people who came in with inspection and with admission, this does not apply to you. So let's talk about the people it applies to. So the first thing is you have to be present in the United States without admission or parole, which means you came in without being admitted, right? That's the first thing. Then secondly, you have to have been continuously present in the United States for at least 10 years as of June 17th, 2024. So let me back that up. That means as of June 17, 2024, which is yesterday, you must have been in the United States for at least 10 years. So this is not going to apply to people who were not in the United States for 10 years as of yesterday, right? Does not apply to you guys. Now, the third thing is you must have had a legally valid marriage to a U.S. citizen as of June 17, 2024. So you must have been married to a U.S. citizen as of yesterday. So if you're planning, even though you've been in this country for 10, 12, 13 years, but you didn't get married to a U.S. citizen until maybe today, it wouldn't apply to you. So there are cutoff dates, which are really important for you to know. So let's go over it again, right? The basic requirements, and I'm reading here the fact sheet from the Department of Homeland Security. So this is their sheet. I'm going through there. So basically, the individual must be present in the United States without inspection, or without admission, without parole. They must have been continuously present in the United States for at least 10 years as of June 17, 2024. They must have had a legally valid marriage to a U.S. citizen as of June 17, 2024. Those are the baseline requirements. So let's talk about the other requirements which are needed, because this is going to be done on a case-by-case basis, right? Which means it's not an automatic approval. You have to prove your case. So the first thing is, well, we talked about the citizen having lived here in the United States for at least 10 years or more as of June 17, 2024. But the second requirement, which is really important for you to know, is that that person must not pose a threat to public safety or national security. Now, what does that mean? Public safety means a person should not have committed crimes that endanger the public, right? And national security is you cannot be a terrorist, all right? And number three is you have to show that you're otherwise eligible for adjustment of status. So what that means is that you're not inadmissible. You haven't done something that made you inadmissible. You haven't committed some crimes. You haven't committed some immigration violations, such as sham marriages, because, once you commit those kind of crimes, you cannot adjust. It doesn't matter if you meet every other requirement. You have to show you haven't committed immigration violations, such as false claims to citizenship, saying that you're a U.S. citizen when you're not. You have to show that you haven't committed some kind of immigration fraud that makes you inadmissible. So you have to show that you would otherwise be able to adjust status. And then the fourth thing is you have to show that you merit a favorable exercise of discretion. Basically, you're worth getting this parole in place, which is what this is called. It's a parole in place, right? So you have to show all of this, and it's discretionary. It's a case-by-case basis. And so what does this tell us? Well, what it tells us is now we have a pathway for undocumented spouses of US citizens, which is great if you meet this requirements. But what it doesn't tell us is the manner in which this is going to be done. And I guess at some point they're going to, give us the guidelines. But Biden says that this is not going to go into effect until sometime this summer. We're not sure when. And I wonder if it's going to be similar to military parole in place, which is the system where you file the form I-131, you get an I-94, which now allows you to file to adjust your status. I'm thinking that's probably something similar. But what I was wondering was, if you're going to do it similar to military parole in place, does that now mean that a waiver is not necessary? You don't have to file a waiver within the United States? I kind of think that's what I'm hoping that's what it is. So if that's the case, the other good news would be that the line, the delays on I-601A will get better, because now you've taken a whole chunk of people who don't need an I-601A waiver, and they're no longer on the line. And so hopefully that helps, the processing of I-601A waivers for people who don't qualify for this parole in place. So another thing that the Biden administration says that would be applicable would be non-citizen children of potential requesters may also be considered for parole under this process if they are, number one, physically present in the United States without admission or parole, and number two, they have a qualifying stepchild relationship to a U.S. citizen as of June 17, 2024. So to break this down, basically, a qualifying stepchild relationship means that the step relationship was formed before the child turned 18. So the parent and the U.S. citizen step parent must have gotten married before the child turned 18. That creates the step relationship, right? And of course, that child also has to have come into the United States without admission or parole. So now the third thing that was mentioned by the Biden administration, which they didn't really talk about it a lot, so it's a little unclear to me, is that they're saying that DHS, Department of Homeland Security, will join the Department of State in an effort to more efficiently facilitate certain employment-based non-immigrant visas for eligible individuals, including DACA recipients and undocumented non-citizens who have graduated from an accredited U.S. institution of higher education. So what does that mean? Well, they're talking about giving work visas to undocumented students who have graduated from an accredited university of higher education, from college, right? Or I don't know if it also includes community college, or it has to be four-year college. It's not clear. Now, this is really great because we have a lot of children who come into the United States. They come in with their parents, and sometimes they come in with B1, B2. Sometimes they come in through, the border with their parents, and they go to school here, but they didn't qualify for DACA because they didn't meet the cutoff. And they're here, they have no pathway to getting a work permit, but they've graduated from college, and America does not get the benefit of them going to the American college. The brilliance of these children, America has shut itself out of the benefit of getting their work effort, their employment, because they don't have work. And I'm hoping that what this means is that the Biden administration will give those kids a work permit so that they can work. Whether or not it leads to a pathway to citizenship, at least allow them to work. So those are the things that were discussed during the Biden during his talk about 3:30 today. But like I said, we're not sure what the process is, but they will let us know what the process is. But I want to tell you this. The good thing about this is this may actually work for people who might have had another pathway. Like I did a consultation a few days ago, and we had somebody who would have qualified for a T visa, but was also married to a U.S. citizen. But because he came in through the border, he couldn't, without this, he wouldn't have been able to adjust his status without having to leave the United States with an approved waiver. So now with this, he qualifies to file, his wife qualifies, his US citizen wife can file for him. He also has the T visa available to him. So at this point, he's going to be looking at which way should he go. Now, for him, he has a child who is, I think 18. And if he files a T visa, his child would be a derivative, and the child would get a green card through through this process, right? The T visa. But if his wife filed for him, the wife cannot file for the son because the son doesn't qualify as a stepson under immigration definition. So a lot of these cases, we're going to be looking to see what serves our clients the best. So that's really it for now. And as soon as we get more information on how the process is going to go into effect, we will be happy to, I'll be happy to come over and talk about it. And, I haven't been this excited since DACA. And incidentally, this is the 12th anniversary of DACA as well. So today is just a great day. So I'm going to take a couple of questions and then I'm going to head out. Let's see. Brittany Clark says, if your dad is a green card holder, can he file for his child who's over 21 and living in the United States? So your father is a green card holder. He can file for his child who is single and over 21, but that child has to be in legal status in the United States for that child to be able to adjust their status and get a green card. If they're not in a legal status at the time their priority date is due, they're going to have to file a waiver, similar to the waiver this families had to file before this new law. They have to file a 601A waiver, show extreme hardship to the parents, and or if they're married to a U.S. citizen or green card holder at that time. Extreme hardship doesn't matter who, anyone would qualify, and then if that is approved, they have to leave the country and they have to consular process, get their green card from an interview outside, and then come back. So that's the answer for you, Brittany. Lion Ray says, what would be recommended for those who already have an approved I-130 but have not sent out the I-601 yet? Will this potential executive action allow us to adjust within the US? So Lion Ray, that's a great question. So remember, this executive action does not apply to everybody. First of all, even if you have an approved I-130, you need to show that you came in without admission or parole. You need to show that you've been continuously present for 10 years minimum as of July 17th, and you have to show that you had a legally valid marriage to a U.S. citizen as of June 17, 2024. So, and then of course the other requirements, which means, no criminal record. You have to show that you're worthy of this, discretion, exercise of discretion. You have to show that you have no other inadmissibilities that would disqualify you from adjusting your status. So, so that's really it. So Glove Master says, what's next after prima facie on VAWA? Well, usually you get your work permit or advanced parole if you filed an adjustment of status application with your VAWA, and then you wait and wait and wait. Sometimes, if you're lucky, you get a response sooner than later, but VAWA is taking a long time. So, okay, I'm going to take some questions from Instagram, and all right. Hello. T. Jokon, Loma 1, Our Brown Sugar. Good evening. Good evening, guys. Good evening. Let me scroll to a question. Let's see. Someone says, where are you in New Jersey? I'm in Cedar Knolls, New Jersey. It's close to Morristown. But we work with clients in all 50 states, so you don't have to be in New Jersey for us to work with you. Let's see. So Daniela says, how does this impact a pathway to citizenship for DACA? This does not. So sorry, DACA is still a problem. It's still in, DACA is still a problem. Congress hasn't acted. So yes, Yancy said, this is a blessing for many families. All glory to God. Indeed, all glory to God. So Sapphire says, I got married, got divorced, and decided to continue the process on my own after already receiving my first green card. However, I haven't received my 10-year green card. I still don't know what's going on with my process after getting a lawyer. The whole process has now frustrated me. Help. So sorry to hear that, Sapphire. So it sounds like you got a temporary green card. Is that what it is? because you're not giving me a lot of information, but if you want us to assist you, you have questions, please feel free to call 973-993-1900 and book a consultation. So just Q Pedro says, how long does it take to receive VAWA EAD after biometrics? It really depends. I tell people anywhere from 5 to 10 months, and that's just an average because it's possible to get it earlier. It's quite possible to get it later, but typically we've seen that most of our clients are getting it within 5 to 10 months. So House of 1987 says, I want to know how much you charge. It depends on what you want to retain me for. So feel free to call my office. Let's see what we can do for you. 973-993-1900. So Eniola Prentice says, is it a work visa or permit? So this parole in place is a pathway to a green card and ultimately to citizenship. And in the process, while they're adjusting their status, they definitely can get a work permit. But like I said, we're still waiting to get all the information on how it's going to be implemented. So Nisola says, what happens to undocumented children of US citizens? Well, like I said, it depends. This law is really specific as to who qualifies. So it's very specific. So if it doesn't apply to your undocumented child, then it doesn't. But your undocumented child might have another pathway. So House of 1987 says, do you take installments? We definitely do. So Fumi Sela says, how do we schedule a consultation? Call 973-993-1900. Somebody will be able to assist you. Or you can go to my website and self-schedule, www.odunlamilaw.com. But typically it gives you a date really, really, really far out in the future. So if it does that, you can call the office and see if you can be, scheduled for something closer, because sometimes we get cancellations. So Dopes Ghanaian says, so does that mean if you enter the country through B1, B2 visa and you're not married, this law doesn't cover you? Exactly. This law does not cover you if you entered with admission, okay? So LJLEO1 says, I have a T visa case pending. Can I file an I-130 as I'm married to a US citizen? So if you definitely can file an I-130 if you're married to a US citizen, but remember, whether this is the best avenue for you depends on your own personal case, the context of your case. So an I-130 may not be the best solution for you. Remember, for you to qualify for this parole in place, you must have come in without inspection. So if you came in with inspection, it doesn't apply to you. So you really want to make sure you hit every single requirement, every eligibility requirement, okay? Right. So Bola Bolitin says, that's one way to reunite families. We need Joe Biden to bring deported spouses back to their families. Thanks so much for analyzing the new immigration law. Yes, Bola Bolitin. Yes, that happens. But there is a way of bringing deported spouses back, but it depends. We've actually done a few in my office, but it depends on the reasons they were deported. It depends on whether they have a qualifying relative to file for them. It depends on a lot of things. So if you have a spouse that was deported, why don't you reach out to us? Let's see if we can get him or her back here. The number to call is 973-993-1900. So Kendrick says, I came into the United States on a student visa. Nope, this does not apply to you. But you dropped out of school, recently got married to a US citizen. But even how hard is it to adjust my status? So if you came in on a student visa and you're married to a US citizen, you can just do it the regular way, which is your US citizen spouse can file for you. You can do it the regular way. You don't need parole in place, because for parole in place, you need to have come in without inspection without admission. So as an F2 student with an expired F2, you can, if you have no other inadmissibilities, your U.S. citizen spouse can file for you, okay? If you need help with that, call us 973-993-1900. So photo says, does this apply with VAWA even after divorcing your U.S. citizen wife? Well, this parole in place does not apply to VAWA. This is not a VAWA case, but if you divorced your spouse and you want to file VAWA, you can do so within 2 years of the divorce. Make sure you file within that time, okay? And MM for real 77 says, nice job, thank you. Sapphire says, answer my questions. I was before all of them. I answered already, Sapphire. So Shola 6187 says, and this is a really great question, would you be qualified if you're coming with someone's passport? Shola, immigration law sees, even if you came in with someone's passport, as long as you were inspected, even if it's under somebody else's identity, you were still inspected. So I don't believe this law is going to apply to you. All right. So, all right. I feel like I'm going to answer a couple more questions from YouTube and Facebook. I'm just going to look at questions that I understand, because some of these questions, the context is not clear. So Political Pen Pusher says, can you owe IRS and still file for US citizens? You can owe IRS and still file for US citizen. However, you have to have been filing your taxes. Owing IRS is not the issue. It's filing your taxes and being on a payment plan. That's what you need to be doing. And if you haven't filed your taxes for many years and then decide to file it just before you apply for US citizenship, that's not a sign of good moral character. And you're likely not to get your US citizenship application approved. So Bukola says, so this new law means my brother would still need to go back to Nigeria and adjust, even though my mother, who's a US citizen, filed for him. That's correct. This law does not apply to your brother. It only applies to undocumented spouses of US citizens, not even undocumented spouses of green card holders. If you're an undocumented spouse of a green card holder, you're still going to need to file a waiver if you need to file a waiver. So this law does not apply to you, okay? So they're really, really, been sticking to the guidelines of eligibility. So look at it before you file so that you're not wasting your money and getting a denial. All right. So Brooklyn Frank said, what if someone was married with a US citizen and got an I-130 approved, then got divorced? Can they file a green card? So, in a case like yours, Brooklyn, I would want to ask more questions to see if you qualify for VAWA, if you qualify for T visa, because if you got an I-130 approved, but you got a divorce and in a regular relationship, they haven't called you for your I-485 interview, you cannot get your green card on somebody else's application if you're divorced from them, unless you're filing for VAWA, you're filing for maybe T visa based on domestic trafficking, trafficking on a domestic setting. But Brooklyn, you might have another pathway. So give my office a call. Let's see if we can help you. 973-993-1900. So Sashalin says, can you file for unemployment while waiting on a pending I-485? So Sashalin, unemployment, that's not a public charge. I think that's what your concern is. Unemployment is something you pay into, which you can get. It's not a public charge issue. Okay. All right. All right, guys. I know there's a lot of questions, but it's 6:31, so I'm going to head out. But if we get more information as to how this is going to be implemented, I'll be here to discuss it with you. But this is really, really great news, and I cannot wait to get more information on how they're going to help undocumented children who are finished, who have finished college, because it's really not fair to children to to have to answer to the have consequences that have nothing to do with what they did, but what the situations they found themselves in. So that's pretty much it. I'm going to sign out, and I'll be in touch when I hear more. Take care, everyone. Bye-bye.